Why is IP protection in AI healthcare ethically complex? Have you ever wondered why protecting intellectual property in artificial intelligence healthcare is such a tricky issue? The ethical complexities arise from various overlapping challenges that touch on ownership, transparency, access, and the nature of innovations created by artificial intelligence. Let's break this down. First, we need to consider who actually owns the intellectual property rights in artificial intelligence healthcare. The systems often use proprietary algorithms and data models developed by private companies or research institutions. This raises questions about whether the developers, healthcare providers, or even patients whose data help train the artificial intelligence should hold the rights. This becomes especially complicated when public funding or diverse patient data is involved, creating a tension between private profit and public benefit. Next, traditional intellectual property laws focus on human inventors. However, artificial intelligence can generate inventions or creative outputs without a human author. Current laws do not recognize artificial intelligence as an inventor, leading to disputes over who truly owns these innovations. For example, patent offices have rejected applications that list artificial intelligence as the inventor, highlighting the need for legal systems to adapt to this new reality. Another important aspect is transparency. Proprietary algorithms in healthcare can be quite opaque. This lack of clarity can prevent healthcare providers and patients from understanding how decisions are made by artificial intelligence systems. This raises ethical concerns about accountability and the right to know how medical decisions are reached. Moreover, intellectual property protection can limit access to these innovations. When artificial intelligence technologies are protected by patents or copyrights, only organizations with enough financial resources can afford to use them. This exclusivity can conflict with the ethical principles of justice and beneficence in healthcare, as it may restrict access to potentially life-saving tools. Additionally, the use of large datasets to train artificial intelligence systems introduces copyright and privacy issues. These systems often requiring vast amounts of data, some of which may include copyrighted or sensitive patient information. Managing data ownership, consent, and privacy is vital to respecting patient autonomy and confidentiality. From a technology law perspective, managing intellectual property portfolios in artificial intelligence healthcare involves balancing the need for innovation with public interest. Policymakers and legal professionals must navigate evolving laws to address issues like inventorship, licensing, and transparency. Practical solutions may include developing open-source frameworks and collaborative licensing models that reflected the unique role of artificial intelligence in healthcare. The ethical complexity of intellectual property protection in artificial intelligence healthcare stems from challenges in defining ownership, ensuring transparency, protecting patient rights, and promoting equitable access. All of this exists within a legal framework that must adapt to the distinctive capabilities of artificial intelligence and the societal importance of healthcare.